Good afternoon. Welcome and thank you for joining us for today's webinar on immigration changes and international students' employment options. I'm Jill McKerney, Head of Immigration and a Senior Associate in the Employment, Pensions, Immigration and Compliance, or EPIC team, and I'm joined by Pip Haig, who is an Associate in Team EPIC. This webinar is intended for companies who currently hire or may wish to hire workers from outside the UK, and for universities who are sponsoring international students. This session is the last of 4 webinars hosted by the Phil Fisher Immigration team in October and November. If you have any questions about today's topic, please use the question box on your control panel on the right-hand side of your screen. We will then collate the questions and try to answer them during the webinar. If we don't manage to get to your question, we will follow up with you afterwards. We will also be using polling throughout the discussion. You will be able to view the polls in your viewer pane once launched. Once you have selected your answer, please click Submit. We will share the results as we move through the discussion. All of our sessions are available on our website and our YouTube channel. So the Department for Education estimated the export value of international students to the UK in 2015 at £17.6 billion. International students are recognised as supporting employment in the local economies where they study. They provide a vital source of income for institutions, cross-subsidising research. International students who leave the UK after study benefit the UK's soft power and foster ongoing business and research links. The government's international education strategy intends to grow education exports to £35 billion a year and to increase the number of international higher education students in the UK to 600,000 by 2030. The coronavirus, together with the impacts of Brexit, poses a significant challenge to this goal. A 2019 report by the Russell Group found that an inadequate visa system can put prospective students off choosing a country as their study destination. It found that the UK student visa process was more expensive than in other countries, and they estimated the cost of compliance for the sector at £40 million and a further £12.3 million for universities in the first year of EU nationals requiring visas. So we'll look at the changes to the student immigration system implemented on the 5th of October 2020 and consider whether they help the sector. At the same time, many employers are facing skills shortages, with tech skills being in particularly high demand. As the free movement of EU workers will end on the 31st of December, with a possible reduction of up to 80% in the flow of EU workers to the UK, employers may look more to international graduates to meet their talent requirements. We therefore will look at the employment options available to international students on graduation. So the changes will require all universities to take action now. So we'll look at the timeline, the requirements for EU students, new changes to the student route, employment options for graduates, sponsorship, and business visitors. So firstly, we'll look at a timeline. I've already mentioned that free movement will end on the 31st of December 2020. The government has introduced an EU settlement scheme for EU nationals to preserve their right to live, work and study in the UK after Brexit. Any EU national who wishes to apply to the scheme needs to have arrived in the UK before 11 PM on the 31st of December 2020. The deadline for them to apply is the 30th of June 2021. The scheme is free of charge and is intended to be straightforward to use. Irish nationals will continue to be treated as permanent residents after Brexit and do not need to apply to the scheme. The new rules for the student visa immigration system came in on the 5th of October. The new immigration rules for employment will be effective from the 1st of December this year. EU nationals arriving from the 1st of January 2021 in the UK will require a visa to work or study in the same way as non-EU nationals. So we strongly recommend that universities encourage EU staff and students to apply for pre-settled or settled status as soon as possible. If they do not apply by the 30th of June deadline, they will no longer have the right to work or study in the UK. We recommend that you also encourage the EU staff and students who will be travelling to the UK to consider arriving by 11 PM on the 31st of December 2020 to ensure eligibility to the scheme. It is possible to apply for pre-settled status on the basis of having been present in the UK in the 6 months prior to applying, and it is possible to rely on a used travel ticket as proof of presence in the UK. So as you'll be aware, EU students starting a course in the 2021 to 22 academic year will no longer be eligible for home fee status or access to financial support unless they are eligible and apply to the EU settlement scheme. This makes it even more crucial for any EU national student to consider whether they can come to the UK before the end of 2020. Regarding the Erasmus Plus scheme, staff and students can complete mobility periods and receive funding up until the end of the 2021 to 22 academic year. EU students arriving from the 1st of January 2021 will, however, be subject to the new immigration regulations. If they're coming for less than 6 months, they can come as a student visitor, or if they're coming for more than 6 months, they will need to apply in the student visa route or the Tier 5 route if they're carrying out a volunteer or work placement. So next I'm going to run through the main changes to the new student rules which have replaced Tier 4 and have come into effect from the 5th of October this year. So firstly, the application window has changed. So you can now apply for permission to enter as a student up to 6 months before the course start date instead of 3 months. If you're already in the UK, you can now switch into the student visa route, which means apply from within the UK from most visa categories. You cannot switch while here as a visitor, however. If you're uncertain if you can switch, please check or get advice. If you do not meet the validity requirements, such as if you apply without a CAS reference, the application will be invalid. This means that you would get the fee refunded, which is good, but without having had an application decided, you could then become an overstayer, which could cause difficulties in remaining in the UK. Regarding then looking at maintenance, if you've been living in the UK for 12 months or more at the time of applying, you no longer need to meet the financial requirement. So looking at English language, there are now additional ways of meeting the English language requirement. You can show that you meet this if you have met it in a previous application. If you are a national of an English-speaking country, and Malta and Ireland have been added to the list of English-speaking countries. Or alternatively now, if you have obtained a GCSE or A-level in English language or literature while at school aged under 18, then you will be exempt from the English language requirement. So looking at the Academic Technology Approval Scheme, nationals of some countries, including EU nationals, do not now need to provide ATAS certificates for postgraduate level courses. So finally, in regard to the new student rules, if you are a national of certain countries, including EU nationals, you do not need to provide proof of your qualifications or of meeting the financial requirement when applying, although these documents could still be requested, so you need to have them available just in case. So finally, the 8-year time limit has been removed for those studying at postgraduate level, which is great news. So this could be significant as it could enable some applicants to apply for indefinite leave to remain on the basis of long residence if they have lived in the UK for 10 years as a student. So having looked at the new student rules, we'll look at our first poll question. So the question is, are you concerned about a drop-off in student numbers in the UK due to the end of the free movement of EU nationals? So I'll just repeat that. Are you concerned about a drop-off in student numbers due to the end of EU free movement? I'll just give you a couple of minutes to answer the question, and I'll ask Pip to tell us what the answers are.
Hi, Jill. Okay, it looks like we are looking at the results, and we've got 100% I don't know.
Okay. Oh, that's really interesting. Thank you. Thanks for participating in that. So, well, we will have to wait and see how things work out. But it seems that at the moment there isn't either way concern or otherwise. So then with that, we'll move on to the next slide, and we'll look at the right to work. So we're looking at this as this will be a factor for EU national graduates entering the job market, and for other non-EU national graduates entering the job market and their prospective employers. So for EU nationals, their sponsors and universities will be needing to obtain additional documents for them in order to be satisfied that they have the right to study and the right to work in the UK from January. So UK employers are required to conduct right to work checks on all prospective employees and keep records. Employers can be subject to fines of up to £20,000 per illegal worker, and in some cases, criminal charges can apply. Currently, EU nationals can rely on their passport and national ID card as proof of their right to work, and can continue to do so until 30th of June 2021. For existing employees, employers cannot require them to show their status under the settlement scheme until after 30th of June. However, you can ask if the employee is prepared to share proof of their status before then. Employers have a duty not to discriminate against EU nationals. For new hires, it seems that employers could be left in a position where they take on an EU national in January on the basis of their passport, who is not eligible to apply to the EU settlement scheme, and who would then have to cease work on the 30th of June 2020 as they do not have sponsorship. For new hires from January, we recommend asking questions at the recruitment stage to determine if the person is eligible to apply to the scheme, and if not, to make a business decision whether to proceed with hiring and with sponsorship. Employers should be aware that the person may be eligible to apply to the scheme through a former period of residence. So we're still encountering people who are not aware that it is mandatory for them to apply to the scheme. So we'll now look at the new graduate route. So after the post-study work visa route was scrapped in 2012, the number of international students applying to remain in the UK to work dropped sharply. The new graduate route is being launched in the summer of 2021, meaning that any eligible student who graduates in the summer of 2021 or after can apply. This route will enable graduates of UK undergraduate or master's degrees to work for any employer for 2 years without requiring sponsorship. The doctorate extension scheme will close, and PhD students will get 3 years permission to remain. Those entering the skilled worker route from the graduate route are considered new entrants and will be eligible for the lower minimum salary. So there will be no maintenance requirements for the graduate route, but the visa application fee and immigration health surcharge fees will apply. Given that many employers are unfamiliar with the sponsorship process and can often be reluctant to invest in the significant sponsorship fees in graduates who they may consider have not yet proved themselves, the graduate route should greatly open up the job market for international graduates in the UK, and it's likely to attract more international students to study at UK universities. If students are required to undertake distance learning due to COVID-19, they will still be eligible to switch into the graduate route if they enter the UK before 6th of April 2021 and complete the final semester of their studies in the UK. So with that, I'll hand over to Pip to talk about employment options for students.
Thanks, Jill. Hi, everyone. So before we start, we're going to have a look at a scenario, which will look at the practical considerations for employers. So here on your screen, we've got the scenario. We've got Sherlock, who's on a student visa, and he works part-time for Mystery Solutions Limited. He's staying in the UK over Christmas and would like to work full-time. And in the long term, Mystery Solutions would like to employ Sherlock full-time when he finishes his degree. So what does Mystery Solutions need to be aware of? Well, Sherlock has a student visa valid from August 2017 to February 2021. His biometric residence permit under the remarks section will state that he has permission to work for up to 20 hours maximum during term time. It also includes his educational sponsor license reference number. So a week is considered in this context to run from Monday to Sunday, and he can undertake any kind of work as long as it's not full-time, permanent, or self-employment. If permission to work is not stated, then the student is not permitted to work at all. We've established then that Sherlock can work part-time, but can he work during the vacation period during Christmas? If a student has permission to work stated on their biometric residence permit, then they're also permitted to work full-time during vacation periods. So this means Sherlock can work over Christmas, provided Mystery Solutions obtain, copy and retain details of his academic term and vacation times covering the duration of his period of study in the UK for which he'll be employed. The definition of term time will depend on whether Sherlock is an undergraduate, postgraduate or a PhD student. Students are not permitted to fill a permanent full-time vacancy unless they're applying to switch into the Tier 2 visa route or the soon-to-be skilled worker route following completion of degree level study in the UK. And what does this mean in terms of his employment? Well, let's say Sherlock completes his course on the 1st of August this year. Students can work unlimited hours after their official course completion date on a fixed term contract during the final 4 to 6 months of their visa. This means that Mystery Solutions may allow Sherlock to start working whilst he has a pending skilled worker visa application, so long as the official course completion date has been reached and they agree to let him start working. If for any reason that his visa application was refused, he would have to stop working. Once Sherlock submits his application to switch from a student to a skilled worker visa, his fixed-term contract can be swapped for a full-time contract. This scenario, of course, is set out purely from an immigration perspective, and a full review of the employment contracts and employment law considerations should be explored. The scenario also assumes that Mystery Solutions has a sponsor license. But what if they don't have a sponsor license? Well, they would need to apply for one and ensure it's granted before Sherlock submits his skilled worker application. As explained by Jill, under the new immigration system, there are strict rules on how to submit a valid application. For example, if Sherlock submits his application without a valid certificate of sponsorship assigned to him, his application could be rejected because it would be deemed invalid. Are there any alternatives? Subject to timing, and if Sherlock's biometric residence permit was valid through to summer next year, he may wish to consider taking advantage of the graduate route. We'll explore some other long-term visa options for employers later in the webinar, but first we'll take another poll question. The question is, are you confident that your organisation and students are fully aware of the visa routes available in the UK on graduation? I'll repeat that. So are you confident that your organisation and students are fully aware of the visa routes available in the UK on graduation? And we'll just allow a minute to receive the results. Okay, so from those who voted, the answer is no. So we will look and explore these visa routes and options in this webinar, so hopefully that will assist you. Okay, so next we're going to look at sponsorship and how this can help employers. So to be able to sponsor non-EU nationals and from January, EU nationals, the company must first apply for a sponsor license. The license application can take about 6 to 12 weeks, and the government are urging employers to apply now to avoid delays in recruitment from January. The system's been made more flexible, And in particular, the minimum skill level has been lowered from degree to A-level skilled roles, and the minimum salary level is being reduced from £30,000 to £25,600. The advertising and restricted certificate of sponsorship requirements are being scrapped. As we all know, it's possible to switch from the student route into the worker route from within the UK. The flexibility to switch visa categories within the UK has been extended beyond the student route, and it's a big benefit to the new system. It widens up the opportunities for recruitments for employers. Previously, many people had to leave the UK and apply from abroad for skilled worker status, which previously was Tier 2 general worker status, and most can now apply from within the UK, and this cuts out the unnecessary costs and delays. It's important to note that visitors still cannot switch into the skilled worker visa category. EU nationals with a chip passport can use the government app to make their application, and they don't need to attend an appointment. The caveat of sponsorship is that it's costly. A 5-year visa can range from between £6,000 to £10,000 in government fees per person. So, what roles are eligible for visa sponsorship? This table shows some examples of what roles are eligible. On the left-hand side, we've got the current degree level roles eligible for sponsorship. And then on the right-hand side, we've got the new lower skilled A-level roles that are eligible for sponsorship under the skilled worker route. So looking at this, for example, under the current system on the left-hand side, we've got human resource managers and directors. And then under the new system on the right-hand side, by comparison, we've got roles such as human resources officers rather than managers and directors, which are roles eligible for sponsorship. And let's not forget, there's further advantages to employing students and graduates, and that is that they can fall into what's known as the new entrant route for minimum salary purposes. The criteria to identify a new entrant to the labour market has been amended. So as recommended by the Migrant Advisory Committee, new entrants will also include those sponsored in postdoctoral research positions and those working towards professional qualifications, registration or chartered status. The criteria for new entrants switching from the student route are being widened to include those who were in the route at any time in the 2 years before they apply. Under the skilled worker route, a lower salary can be paid, with the absolute minimum salary, which equals or exceeds both £20,480 per year and 70% of the going rate for the occupation. And there are similar ways in which the skilled worker route has become more flexible. For example, the minimum salary requirement for a job in a listed health or education occupation can attract a salary which equals or exceeds both £20,480 per year and 80% of the going rate for the occupation. PhD level roles are exempt from the immigration skills charge, and this can also reduce the government costs by between about £1,800 and £5,000 per person for a 5-year visa. The same savings apply to UK graduates who are sponsored. So it seems like the system is becoming more flexible in certain ways, but more restrictive in others. And the burden and cost of sponsorship is still significant, and employers may have to look at alternatives such as apprenticeships and hiring more graduates. The government may consider whether the sponsor has shown a genuine need for the job and whether the applicant has the appropriate skills, qualification, and experience needed, as well as the sponsor's history of compliance when looking at a skilled worker application. Next, we'll look at further considerations for employers, such as skill shortages and how this impacts employment options for international students. Immigration may have fallen off the radar for many employers who may have been focused on the fallout from the coronavirus. In terms of priorities, it really needs to be moving up the list, move to the forefront of the minds of employers. Statistics tell us that there are substantially fewer visa applications made in March this year compared to last year, and Tier 2 visa applications were typically made from India, USA, Philippines, Australia, Nigeria. It's likely that these facts and figures are going to change once EU nationals are included in the application process, but the direction of change is currently unclear. Perhaps there'll be a rise in the number of applications, or perhaps the trend in numbers will continue to decline. So what do these changes mean for the UK workforce, and how will Brexit and the coronavirus impact the resident labour market? Well, as part of our webinar series, we discussed this with 3 industry-leading experts from Fieldfisher from various sectors, including technology, life sciences, and employment. The fundamental takeaway was that employers are having to rethink how they will recruit from 2021, and they will need to how they will retain, their existing workforce. Could it be that students and the courses that they decide to study determine how the UK's labour market looks in the near future? And will this detrimentally impact the variety of roles available and the demand for jobs? I mean, maybe not. It's arguable that the changes to the skilled worker route will help to resolve these potential skills gaps in the UK. The £25,000 threshold and tradable characteristics of the points-based system seem to favour experience, and this could detract from the role of students mentioned. But does this mean that employers need to be considering getting more involved in sponsoring undergrads in order to ensure that they can fill junior roles, which are no less skilled? And finally, should employers be looking at other long-term visa routes? So we'll have a look at this now. On your screen, you can see that we've got listed the global talents routes, the innovator and the startup routes. These routes don't require visa sponsorship, and in turn, they incur less immigration costs. So we'll look at these and then the strategies employers can take and how they can use student visa routes to their advantage. So firstly, global talent. So from January 2021, this route will be open to EU citizens on the same basis as non-EU citizens. The most highly skilled, who can achieve the required level of points, will be able to enter the UK without a job offer if they're endorsed by a relevant and competent body. This scheme has recently been expanded to be more accessible to those with a background in STEM subjects who wish to come to the UK. Then we've got the innovator route, which replaces the Tier 1 entrepreneur route. It's useful for established entrepreneurs who set up a business in the UK and the business or business idea has been endorsed by an approved body. The applicant will need £50,000 to set up the business, but if the business is already established and endorsed, or if the business changed with the agreement of the endorsing body, these funds are not required. So this could be useful if you are the innovator employer seeking to recruit employees, but also if you're an employer seeking to contract with a person with an innovator visa. Then we've got the startup visa. So this replaced the Tier 1 graduate entrepreneur route and is for aspiring rather than established business persons. And this means that you don't necessarily have to show that you have much experience. There are some downsides. It's temporary in nature, so you would have to switch to another visa category after 2 years. So what strategies can businesses take to help themselves? I mean, this essentially means working out how to retain your current workforce. This could be by upskilling existing staff, issuing promotions, making lateral moves into other areas of the business. And if you already employ students on student visas, there could be an advantage to retaining them. It could involve taking advantage of the relaxed provisions under the new immigration system for non-EU nationals and hiring more non-EU nationals. Or perhaps a French national resident in the UK before Brexit could apply to the EU settlement scheme. You could hire individuals through the graduate route, and businesses could also consider taking advantage of switching. Next, we'll look at the practical steps that businesses can take. Well, workforce continuity and immigration compliance are key risk areas for businesses. You need to be able to recruit and move your staff as and when needed. The first step is going to be to identify the current position. We suggest you conduct a workforce audit to identify your EU population in the UK and your UK population in the EU, and identify any skills gaps you currently have or will have in the future. Many EU nationals are independently choosing to move elsewhere in the short or long term due to Brexit or COVID, and this may leave skills gaps. Secondly, you need to review how the new immigration rules impact your current processes, including recruitment, immigration policies and compliance processes, and whether your team has training needs around these areas. Thirdly, you'll need to strategize. If you're in the UK, you should look at whether you need to apply for a sponsor license. If you already have one, you may need to increase your allocation of certificates of sponsorship. We've seen that sponsorship carries with it additional costs. It's going to be crucial that you budget adequately for these and allocate resources to managing the process. You may wish to consider if you can increase the sponsorship of non-EU nationals to fill these skills gaps. Finally, you'll need to manage and implement the change. And this just means communicating to staff members responsible for recruitment and management, updating your processes, and taking legal advice where necessary. Lastly, we'll look at short-term business visitors. This may be useful for universities welcoming visiting lecturers or employers inviting individuals to the UK for a business visit. From the 1st of January, those who don't qualify to the EU settlement scheme will be considered non-visa nationals. This means that EU citizens don't need a visa to come to the UK for a period of less than 6 months, unless it's a requirement of the immigration category under which they're entering. EU citizens can therefore visit the UK for business trips, provided they can demonstrate that they're entering the UK as a genuine visitor for the purpose of carrying out business activities. Types of business activities are restricted. Visitors are not able to undertake productive work, and the category can't be used to circumvent the work visa requirements. This means that genuine visitors must be able to demonstrate that they don't intend to work in the UK and that they will only undertake permitted activities. The length of the visit doesn't determine whether a work visa is required. The overarching limitation of the business visitor route is that permission to enter is required prior to entry in order to be able to work in the UK. Visitors are not allowed to fill a role or provide short-term cover within the UK, and they mustn't be paid in the UK. This route is becoming a lot more popular with businesses planning one or a short series of visits to the UK. And what we would highlight to those businesses is that this immigration route is complex. It's also likely that it's going to be changed in the near future. We suggest that anyone seeking to use this route obtains legal advice before travelling. Finally, what are the takeaways from the webinar? Well, really, we've got less than a month to go. It's important to keep yourself updated regularly. Keep communicating to those responsible for implementing the changes at your organisation, and it's important, fundamentally, to take advice where necessary. So I believe we're out of time, but those who have sent questions in, we will get back to you directly after the webinar. So that's all we have time for today. Thank you everyone for joining today's session on immigration changes. We hope that you found it useful. I mean, as mentioned, all our sessions are recorded and can be found on our website and the YouTube channel. Thank you for tuning in. Please join us next time for our next webinar series, which will be in the new year. Thank you. Goodbye.